Hello, this is Matt on the Moon Lambeau channel. Ripple dropped a new legal brief today, and attorney Jeremy Hogan said, quote, Ripple starts off vicious, end quote, and I'll show you exactly what he was talking about. I also have perspective from other attorneys within the XRP community, as well as perspective, a quick comment from Stuart Alderati, who of course is Ripple's chief legal officer. And there's actually a lot more interesting stuff in here than I anticipated, including Ripple talking about on-demand liquidity, the fact that from a legal perspective, they're going to push back, as it pertains to on-demand liquidity, post-complaint. So, dates after the dates that were cited in the SEC v. Ripple case from the get-go. There's all sorts of stuff in here that was very interesting. But before going further, I do want to be clear, I do not have a financial background of any kind. I am not offering financial advice, and you definitely should not buy or sell anything because of anything I say or write. I'm just an enthusiast who enjoys making YouTube videos about crypto-related topics, but just as a hobby and just for fun. Shout out and credit to XRP community member and attorney James K. Filan for sharing this recent document. This is actually just from this afternoon, so this is brand new stuff. And he wrote here, breaking, Ripple files its opposition to the SEC's motion to certify interlocutory appeal. And just as a quick reminder, I'm sure most of you are, but probably just about all of you are aware, that the SEC is seeking to appeal Judge Torres' decision, and not having to do specifically with whether or not XRP itself is a security. That's done, and even the SEC has stated publicly, in a court document actually, to Judge Torres no less, that they're not going to seek appellate review on that. So that's done. XRP has legal clarity, it's done. So that's fantastic. But they are seeking the appeal on other things having to do with the case, other XRP-related transactions regarding Ripple where they didn't win. And so they did win, just as a reminder, with the institutional sales specifically, but not with programmatic sales. And so they're pushing for this, and I'm very skeptical that this is going to go through. I think that Judge Torres is going to give him a big fat thumbs down, and deservedly so. And so to kick things off here, I want to read off just a small part, and then I want to get straight into comments from Stuart Alderati and the other attorneys that are in the XRP community. So let me go down to just the introduction, just a little snippet. Yeah, right here, the part that I've got highlighted. This is all I wanted to cover, just so you understand, like, what it just in its most simplest terms, what is the crux of the matter? What is being argued here? Well, here's what Ripple's legal team wrote in the introduction. The court did not rule in the SEC's favor on all issues. Let's pause it. That's putting it lightly. The core issue, whether or not XRP itself is a security, ruled in favor of Ripple, and ultimately, as a result, in favor of XRP holders. So I appreciate the calmness and professionalism from Ripple's legal team, but I ain't got to be professional. Them bitches lost. And then Ripple's legal team writes, in response, the agency is now rushing to appeal what it claims is a purely legal question applicable to every digital asset case. But the SEC's latest shift of litigation positions to further its desired goals, like its earlier ones, shows no allegiance to the law. And so there you can already see guns ablaze in here, citing, and that's the quote from Magistrate Judge Sarah Netburn. And she said that the SEC was engaging in hypocrisy, and said that they didn't have a quote allegiance to the law. I believe she said there's no faithful allegiance to the law. I think that was the full quote. And so they're citing that here. And so again, the core issue here is that, if you're going to appeal, in order for this to move forward, it has to be a purely legal question. It shouldn't be about all of the incredible details, because there's so many facts and circumstances specific to the SEC v. Ripple case. If you're going to appeal like we're talking interlocutory appeal here, it's an expedited appeal, then it's got to be on purely legal issues. And so they're noting here that the agency, again, they write here, in response, the agency is now rushing to appeal what it claims is a purely legal question applicable to every digital asset case. Okay, so they're claiming that now. This is applicable to every single digital asset case. What did they argue during the SEC v. Ripple case, and what have they argued consistently in other cases? That it's about the specific circumstances for each individual coin. That's what they're saying. And you'll see as we go forward here, because it's thrown in their stupid little faces by Ripple's attorneys and highlighted by attorneys within the XRP community, so we can all just rejoice and laugh at them. And it's fantastic. And so here was Stuart Alderati. He reposted what was shared by attorney Filan, and Stuart Alderati, Ripple's chief legal officer, wrote, Ripple just filed its opposition to the SEC's request for an interlocutory appeal, which is interim appeal. Worth a read, in my opinion, especially the footnotes. Footnote 5. So I actually did print this thing up and I read the whole thing. Here I'll pull it up on the screen too. I got some dead trees up in my little Moon Lambo fingers here. It's got to go down to page 12, I believe it is. Let me scroll on down. And this was interesting because part of what's cited here actually has to do with the SEC's acknowledgement that they're actually not going to be appealing the decision, specifically having to whether or not XRP itself is a security. But still, Ripple's attorneys, interestingly, are taking issue with part of this. So check this out. Footnote 5. This is what Stuart Alderati was talking about. The SEC states it does not, quote, does not seek appellate review of any holding relating to the fact that the underlying assets here are nothing but computer code with no inherent value, end quote. So let me pause there already. That was the part where once we saw that, we knew that the SEC had thrown in the towel. Not against Ripple, but as it pertains to anything that would matter to you and I on an individual level, just as XRP holders, that's when we just knew right there, they've given up. This is fantastic. That was gigantic. That was the biggest legal news for the XRP community since the decision dropped July 13th, henceforth known as XRP Victory Day. So that's what that is. That's fantastic. It's still fantastic here. But Ripple takes issue with a substantial part of this because they said that it's just computer code with no inherent value. And so then the rest of the footnote reads as follows. The court made no such ruling. To the contrary, undisputed evidence established XRP's inherent utility as a bridge currency to facilitate cross-border transactions. Instead, the court found that an XRP token is not in itself an investment contract because it does not in itself meet Howey's requirements. Okay, so that's the end of the footnote, and you can see what they're citing here specifically is the SEC's claim that XRP has no inherent value. Now, to me and you, this is inconsequential. It's still fascinating that they're arguing this because really when they say inherent value, you know what a synonym is for inherent? It would be intrinsic. So then you're back into this argument of intrinsic value, and this would be too far outside the scope of this video, though I do find the topic very interesting here. But, I still think, if something's valuable, people have got to use it and find value in it to make it useful and so that it has utility. Because otherwise what you're citing, even if you're just talking about computer code like the XRP and the XRP ledger, you can cite all the things that are in the code to make it valuable, but what I would argue is that those are intrinsic qualities. So there are intrinsic qualities that are part of the computer code, but that's different than intrinsic value. Those intrinsic qualities make it possible for there to be actual value and actual utility. So I get why Ripple's arguing what they're arguing. But, if they're talking about like XRP's just, it's valuable even if nobody uses it, I struggle to see that. So because they're right. But see, then you can get to this whole semantics argument. Is everybody using the word the same way? Is everybody using the word value the same way? Is everybody using the word inherent the same way? Is everybody using the word intrinsic the same way? And the answer is probably no for all three of those. So it gets really messy real quickly, which is why I don't want to go any further down that path. But yeah, obviously XRP just oozes utility. It's one of the most useful cryptocurrencies, if not the most useful cryptocurrency on the entire damn planet, which is incredibly rare. So I see why they're taking issue with that from a legal perspective. It just seems like a smart legal move to fight back against something like that. Of course, that also has nothing to do with any of the Howey factors, but I don't mind seeing this. Then here you have this from attorney Jeremy Hogan. He writes, Ripple starts off vicious with the Youngers case, screenshotted on the right. And I'll pull that up in a second. The case says that the issue to be appealed must be one of pure law. And the SEC has an issue that's part bloodhound, a little chihuahua, and half mutt. It's a high hurdle to jump over the SEC. And then he shared this screen grab from the legal brief that Ripple filed today. And it reads as follows. The heading is, the SEC's challenge does not raise a pure question of law. And again, as I cited in reading that introduction, that's what's at the heart of this argument, because it has to be a pure question of law, not the specific circumstances of the SEC v. Ripple case as it pertains to XRP or any of the transactions therein. Can't be about that, not for an interlocutory appeal. So that's the bar that has to be met. And we know that in this case, so this is just the SEC speaking out of both sides of its mouth, and Judge Torres is not going to fall for this. They're just not acting in good faith. But they had argued, of course, it's just about XRP until suddenly it's not. And so Ripple's attorneys write, the first condition for certification is that the order to be certified must involve a controlling question of law. The statutory phrase question of law refers to a pure question of law that the reviewing court can decide quickly and cleanly without having to study the record. Okay, and so then they reference the Youngers case, which I wasn't familiar with, but that doesn't really matter. And here's the screen grab of that, which attorney Hogan shared. And I'm just going to read the top part, and if you want to pause and read the whole thing, you can, but the most relevant portion is right at the top, and they say, a question of law must refer to a pure question of law that the reviewing court could decide quickly and cleanly without having to study the record. So that's where that came from. And so let me now go back to the first screen grab that attorney Hogan shared. Here we go. So the rest of it reads as follows. Yet here, the court's order examined the totality of circumstances surrounding defendant sales of XRP. It found that the institutional sales, which the SEC alleged amounted to $728.9 million, were sales of securities, while the programmatic sales and the other distributions, which the SEC alleged amounted to more than $1.3 billion, were not. The court did not make those rulings without having to study the record, nor would the Second Circuit be able to review the court's order without doing so. Okay, so again, that's why they're hammering this point. Because as a matter of law, that's what the bar is. If you have to actually dig in and review the specifics of that case, and it's not just a surface level question of law, then no, you don't get the approval of the interlocutory appeal. And the SEC knows this, but they're doing what they're doing because they're asshat pricks. The little spawns of Satan. Winged little bitches. They bite too. Here we have attorney John Deaton, and he wrote the following, sharing the screen grab, which is on your screen for those of you that care to look. As expected, Ripple demonstrates that an interlocutory appeal here is simply not warranted. The SEC has always maintained how it is a fact-specific inquiry, and for an interlocutory appeal to be warranted, the Second Circuit should not have to review the extensive factual record. Footnote 2 destroys the SEC's argument on this matter. And so I don't need to read everything that's on your screen, but let me jump up to the top right around here where I'm circling, which reads as follows. And this is from Ripple's legal team. Until it decided to seek interlocutory appeal, the SEC itself had always taken the same position in this case. Whether or not a particular transaction involves the offer and sale of a security will depend on the facts and circumstances. Now, folks, I'll just pause to note what I'm reading, and if you're looking at the screen, you know this already. That's a quote from the SEC. Again, whether or not a particular transaction involves the offer and sale of a security will depend on the facts and circumstances. So they already argued that in this case, and now what are they saying? Because this is what would suit them now if it were to be true, and it's not, which is why it's inconvenient for them. But it just applies to everything. It's just about pure law. It's not about the specifics of this case anymore. Because if it's about the specifics of this case, they don't get their interlocutory appeal, and they're little whiny bitches. And they're liars. So they're doing it again. They're absolutely dishonest, disgusting creatures that I'm pretty sure nature accidentally made. And anyway, and then Ripple's attorneys write, indeed, in its affirmative motion for summary judgment and its opposition, the SEC submitted more than 2,000 factual assertions that it claimed were relevant and material. Because the questions the SEC presents for interlocutory appeal would require the Second Circuit to review this court's application of the law to the evidence adduced in the parties' summary judgment motions, and an interlocutory appeal is inappropriate. And then they go into cite... This is why Attorney Deaton said footnote number 2 kills it. I'm not going to read it all, but they cite multiple cases where the SEC was arguing what Ripple is now stating to be true and what the SEC stated was true before it was inconvenient for them in the SEC v. Ripple case. So they cite this SEC v. Green United case, which is a crypto case that I happen to have not heard of. I actually lightly skimmed the document before recording this, and it looks like it kind of sounded like a Howie type situation if the way the SEC asserted is true, and I doubt that because they're the SEC. But it's like it had to do with like a mining operation for this green token, which I'd never heard of, in which it sounded like this green token, whatever it is, would be dispersed to anybody that buys into this. Like they would take on the mining for it. I don't know. Don't take it as gospel. That's what it looked like to me on the surface, but I just slightly perused it. So that was one case. They go into cite the Coinbase case, And there's some others in here. I don't really need to read. Again, if you want to read the rest, it's on the screen. Right? But the point is, they use the SEC's own words against them, and it's just like, wow, chef's kiss. It's beautiful stuff here. It's absolutely beautiful stuff. And so I don't see how they thought they would get away with this. They just do stuff. They just don't care, and they're wasting everybody's time and money. Maybe that's the goal. I don't know. God, these are terrible people. They're just the worst people that exist. My God. Can you imagine, like, raising these little hell spawns and, like, being the parents of this? Like, oh my God. Here's a separate tweet where Attorney Deaton said, in part, Judge Torres will not grant this interlocutory appeal. So you know the way he's betting. Same here, man. Then we had this from Attorney Bill Morgan. He said, the action is always in the footnotes. I went on for weeks after the decision about Torres not being correct about sales to ODL customers and could not generate any debate in the XRP community. Ripple will oppose post-complaint ODL sales being categorized as investment contracts. Okay, so this topic is interesting. Just because there were past sales that Judge Torres did find to be infringing from a legal perspective, it doesn't mean that there's not a way to conduct such transactions in a legal way. Now, let's just say that a Judge Torres was right. Now, I'm not convinced with that part of her argument, but let's just set that aside. And I haven't wasted too much time on that because, let's be real, it's not consequential to you or I specifically, and I still think there's a path forward for Ripple, so it's honestly a big nothing. So the SEC got a tiny win here technically, but they didn't get what they really wanted, because they wanted this to be precedent that they could cram down the throats of everybody else and strike fear into the entire crypto industry so they could tear it to shreds, but they didn't get that, those little pricks. But here's how footnote number 1 reads. Ripple disputed the SEC's inclusion of Ripple's ODL sales in its categorization of institutional sales, objecting generally to SEC's invocation of institutional sales. Regardless of whether Ripple's pre-complaint ODL sales were properly categorized as institutional sales, Ripple will defend any attempt to base remedies on post-complaint ODL sales by showing that these sales lack the characteristics the court relied on to find that Ripple made sales of unregistered investment contracts. Folks, so let's pause here. You see what they're doing here? They're noting here, and I'll read the rest in a second, but what they're doing is they're pointing out that, okay, we're not ceding that ground, but even if it were true, we're not conducting these sales the same as back then. So here's what they're doing different. Check this out. This is the rest from Ripple's legal team. For example, the marketing relied on by the court dates back to as early as 2013, which is far removed from post-complaint ODL sales. In addition, post-complaint ODL sales have no lockup provisions or resale restrictions based on XRP's trading volume and contain express provisions that commercial customers must use the purchased XRP to facilitate cross-border payments, noting certain contract provisions stating that an institutional buyer was purchasing XRP solely to resale or otherwise distribute and not to use XRP as an end of use for any other purpose. So there you go. So literally, the actual contract with customers is literally completely different. Do you see what I'm saying? So the customer is agreeing that it's purely for utility purposes. So how could it satisfy Howie if there's no investment of money with expectation of profits on the effort of anyone? Because that's what Howie is, right? So it's not. That's the point. The lawyers looked at this and said, okay, well, how do we square the round peg into the square hole? And they did it. This is how they're doing it. It absolutely, if it came to Howie again, wouldn't be satisfied. So, and again, not that I'm convinced that, Torres ruled properly, but I don't think we need to waste time on it. I just don't think it matters to us here in the XRP community, and I don't think it's going to matter to Ripple. I really don't. We'll see, but I really don't. Here we have XRP community member and attorney Fred Rispoli. Here's what he had to say. Hard for me to see Judge Torres certifying the SEC's request. Legal analysis weighs in favor of Ripple, but I think the standalone reason to deny is the prejudice to Brad Garlinghouse and Chris Larson. Actual humans and not a company. Similar analysis to the U.S. right to a speedy criminal trial. In my opinion, the only way she certifies is if she decides, this is a very political case that I don't want to get too deep in the middle of, and I'll just punt to the Second Circuit and let it decide itself whether to agree, then it's on them. And I don't see, and then he wraps up by stating, and I don't see Judge Torres thinking like that. Interesting stuff here. I'm not a financial advisor. You should not buy or sell anything because of anything I say or write. That would be a very, very, very bad idea. Until next time, to the moon, Lambo.